Hello everyone, a very good evening. Welcome to Oliveboard. This is the CAIIB Foundation for June 2025 and we are covering all the units from all the modules of the BRBL paper. Today we have the unit 19 from module C, Introduction to the Insolvency and Bankruptcy Code of 2016. So all of these sessions that we are having daily on YouTube are very important for your exam preparation, so make sure that you watch all of these videos. If you haven't yet subscribed to the channel, make sure that you subscribe so that you do not miss any updates. Now, when we talk about the Insolvency and the Bankruptcy Code of 2016, which is also known as IBC. So, prior to the enactment of the IBC, India had multiple overlapping laws that governed the various facets of corporate rescue or the insolvency process, and there wasn't a comprehensive legal framework which could be applicable to the troubled or defaulting companies, right? So, to solve this problem, the IBC code was brought. Now, there are two terms in the IBC. First, we have insolvency and then we have bankruptcy. So, what is the meaning? The terms are related but different. Insolvency means when an individual or the organization is unable to meet its financial debt towards its lender and it becomes overdue. So the financial institutions or the banks, they identify that the company, organization or the individual are not paying their debts, and the insolvency can be resolved by changing the way or the repayment plan for the loans or writing a part thereof. So we are not selling off the property or we are not dissolving the organization. What we are doing, we are trying to restructure. Restructure. If only it cannot be resolved in the restructuring pattern, then a legal action may lie against the insolvent and then the assets will be sold off to pay off the outstanding debt. So, first we will try to help the organization recover. There can be circumstances because of which the organization only temporarily is unable to pay off its debt. So, to make the organization profitable again, to enable it to pay off its debts and financial obligations, the insolvency resolution procedure may be taken. For this, an official assignee or liquidator appointed by the Government of India realizes the assets for the insolvent. Then, if we talk about bankruptcy, we know that insolvency is where the individual or corporate is unable to pay its debt, but the bankruptcy is where the individual or the organization they themselves declare as insolvent. It is a legal declaration either voluntarily by the debtor or at the instance of the creditor. They are saying that I have gone insolvent. Please sell off my property or recover the dues. So the bankruptcy is where the person voluntarily declares themselves as insolvent and goes to the court. So the court is responsible to liquidate the personal property of the insolvent and hand it over to the creditors. So here directly the legal procedure will be taken. So we have the difference between insolvency and bankruptcy, right? Then under the IBC there are four pillars. We have the Insolvency and Bankruptcy Board of India. We have the National Company Law Appellate Tribunal, the NCLT and the NCLAT. We have the insolvency professionals and the information utilities. These are the four pillars that will take on the procedure of the CIRP or the liquidation. So the insolvency professionals to assist the completion of insolvency resolution, the liquidation and the bankruptcy proceedings, and they will maintain the professional standards and codes of the ethics as the first level regulators. Then the information utilities are going to collect, collate and authenticate as well as disseminate the financial information. They will also maintain the electronic databases on the lenders and the terms of lending, right? Then we have the NCLT and the NCLAT, which are the adjudicating authorities. They are going to listen to the complaints, the cases relating to the insolvency of the corporate persons, right? So NCLT will hear the insolvency of the corporate persons. We also have the DRTs, which will be the forum for the insolvency related to individuals and partnership firms. Right? So NCLT related to the corporate, the limited liability entities, and DRT to the individuals and partnership firms. Along with them, we have the appellate bodies also, NCLAT and DRAT, where the higher appeal can be preferred on the orders of the NCLT or the DRT. All right. And we have the IBBI, the Insolvency and Bankruptcy Board of India, which will have the regulatory oversight over the insolvency professionals, agencies, as well as the information utilities. So these are the four pillars of the framework. Then we have the CIRP, the Corporate Insolvency Resolution Process. It can be initiated by the financial creditor or the operational creditor or the corporate debtor itself. Now, you should know the difference between a financial creditor and the operational creditor, the financial debt and the operational debt. So, financial creditor is where a financial debt is owed. Operational debt refers to the provisions of goods and services or employment in respect of payment of the dues arising. So both of these are different, right? So CIRP is the process for the insolvency resolution. All right. So it starts with the admission of application for the initiation of CIRP. Then the insolvency resolution professional is appointed. The committee of the creditors are constituted. And finally, the resolution professionals are appointed who will take on the process of the CIRP. Right? So wherever the default is rupees 1 lakh, this amount has been increased to rupees 1 crore. Then the creditor may initiate the CIRP. There can be two independent stages here. First is the insolvency resolution process, where we are trying to resolve the situation, we are trying to provide a restructuring. However, if it does not work, or the financial creditors decide to wind down and distribute the assets to the debtor, then it will be known as their liquidation. So there are two stages, first stage and the second stage. So under the CIRP, the management can be changed or the restructuring can be made or any step to revive the organization can be taken. All right. Then under the liquidation, simply the sale of the assets will be made in the market and the debtors will be paid from the arisings from that. Now, when this is the CIRP that we discussed, if the second stage of liquidation is taken, then how will be the proceeds of liquidation distributed among the various interested parties? For that, a very important mechanism, the waterfall mechanism, is used. It determines the priority. So whatever receipts are generated from the liquidation process, first they will be used to pay off the debt, pay off the insolvency resolution cost and the liquidation cost that was undertaken by the agency, the resolution professionals. Then second on the priority list are the workmen dues. All the people who were employed for 24 months before the commencement of the process, liquidation process, and debts to the secured creditor. And here the secured creditor has the option, either they can use their secured asset to recover their amount, or they can give it to the resolution professional who have relinquished. So this will known as the relinquished. So the secured creditor who have relinquished their security interest will be on the second priority. Then on the third, wages and unpaid dues to the employees will be paid off. Then the financial debts to the unsecured creditor and the workman's dues for the earlier period. The crown debts and debts to the secured creditor following the enforcement. Crown debts are those taxes which are owed to the government. Then the remaining debts, preference shareholders, and finally the equity shareholders or the partners are paid off. So this is the sequence which is followed, or the priority in which under which the payments will be made to the interested parties. And then we have certain other things like who can make an application, or persons who are not entitled to make an application. All of these things are important from this chapter. Then the moratorium period, the time limit, how the application will be made, or how the appeal can be made. These are the other details. The important ones we have discussed. We have also stated here the liquidation steps. Now, if you want to join the CAIIB Super Elite plan, which is the all-in-one plan, you'll get all your papers, live classes, mock tests, as well as your notes. So you can subscribe to this plan now and use the code HNY, which is the New Year Bash offer ending on 9th of February. If you use this code to enroll, you'll get 52% off on your CAIIB subscription. So enroll now, the classes have already started, and join the course. That is all for today. You will find the link to the course and other details in the description box. Also, you can download the PDF. The link is also there. If you have any doubts, any queries, any questions, you can ask me in the comment section. I will see you again tomorrow with the next chapter. Thank you and all the best.